Heil. I'm a partner at the law firm of Prince Lobel Thai here in Boston. And I'm here on behalf of a group of news media and public interest organizations that have a profound interest in the matters that are before you. They are the New England Newspaper and Press Association, the New England First Amendment Coalition, Courthouse News Service, and Bloomberg BNA. On May 1st, our office sent a letter to this committee asking it to take steps to restore civil Superior Court docket information to the public and to overturn what had been what I understand to be an unintentional restriction of that civil docket information to attorneys only. And we're gratified to hear that there are plans to make those civil dockets once again available to the public. But at present, only Middlesex and Barnstable counties currently have access to civil Superior Court docket information, whereas the counties of Essex, Nantucket, Dukes, Bristol, Hampshire, Franklin, Berkshire, and Worcester are all on masscourts.org, but you need to be an attorney to see those cases. And we'd be interested to know if there's a timetable for flipping the switch to allow those to be accessible without an attorney login. As we explained in our May 1st letter, public access to court records is not just a public benefit in the here and now. It is a part of this Commonwealth's proud legal heritage. The Body of Liberties of 1641 provided that every inhabitant of the county shall have free liberties to search and review any rolls, registers, or records of any court. 1641. Docket sheets in particular, which our letter was about, permit the public to actually serve the essential oversight function that people have spoken to about today, about why we have public access. And Justice Oliver Wendell Holmes identified that oversight restriction in a case that oversight purpose in a case going back to 1884. More recently, in the Pellegrino case out of the Second Circuit, the court held that docket sheets must be public under the First Amendment because they endow the public and the press with the ability to exercise the access rights that are such an important part of our legal heritage. And you've heard from journalists today about the importance of access to court records. We understand the committee is going to continue its work to look at these rules, and as many other speakers have done, I'd like to offer what our coalition considers to be the important guiding principles. First, as has been said by other speakers, dockets and court documents should be every bit as public online as they are on paper. It is certainly true that putting information online makes it more conveniently available to the public. That serves the long-standing principle of publicity and oversight that I just mentioned. It may also be true that putting stuff online makes it more convenient and means less practical obscurity for those documents, making public dissemination of that information more likely. But that is exactly what our legal system intends. The Supreme Court in 1975 pointed out that, quote, the freedom of the press to publish information in public records is of critical importance to our type of government in which the citizenry is the final judge of the proper conduct of public business. That's the Cox versus Cohen broadcasting case. And the law has been pretty clear for a long time that, strictly speaking, there is no privacy interest in court records and information that are publicly available in a courthouse. There is no such privacy interest. There are legitimate privacy interests that come up in court proceedings all the time, and we have a well-developed body of case law to deal with that. It's impoundment and the Massachusetts Uniform Rules of Impoundment Procedure. It may be that putting court documents online might result in attorneys being more keen to the privacy interests of their clients and perhaps more likely to move to impound court documents. But it is what the rules of impoundment procedure say that the courts have to take impoundment matters on a case-by-case basis, considering the public's right of access to the particular information being sought to be impounded and balancing that against the privacy interests involved. So what this committee, we respectfully suggest, should not do is go through different types of documents to be filed in court and which are routinely filed in court and say, well, those may be public in the courthouse, but they should not be public online. There is already a well-developed body of case law on impoundment, and it ought to be, impoundment ought to be the solution to the privacy issue to the extent there is one. We've also heard folks talking about inaccurate docket sheets as a reason to withhold docket sheets from the public. That, I respectfully suggest, is an argument for more accurate docket sheets, not an accurate for restricting access to the public. Certainly also the issue of personally identifying information and identity theft has been raised before you. The answer to that question rests in the court's interim guidelines about personally identifiable information, which put the onus squarely on attorneys to redact such information before it gets filed. On all of these questions, the committee, we respectfully suggest, ought to rely on attorneys to do their jobs, keep matters out of the public record if they can satisfy the good cause standard for impoundment, and redact personally identifiable information, not to take wholesale measures to restrict access to documents which may or may not have such information in them. The second principle, very briefly, we'd like to suggest is that there should be no differing types of access between different classes of people. Access to documents, whether they are put up in full text online or in docket, should be equally available to attorneys and non-attorneys, including journalists, pro se litigants, and the general public. And we're pleased to see that masscourt.org appears to be moving in that direction. But the court should also take the same approach when it gets to the point of putting full text court documents online. That, of course, is what the Supreme Judicial Court itself said in its 2003 policy statement about online records, where it said attorneys, litigants, and the media should have no greater access than the general public has to information about cases in which they're not directly involved. That is the Supreme Judicial Court's current statement on the issue. Finally, and I'll wrap up with this, is documents should be available free of charge if possible. Court documents, as has been said before, are public documents, and the court should not be creating any barriers to access if they can be avoided. If any fees are charged for access, they should be reasonable and should be applied equally among all different people seeking access to those court documents. So on behalf of NENPA, NEFAC, Courthouse News, and Bloomberg BNA, I'd like to thank you again for the opportunity to make these remarks today and to suggest we'd be happy to help the committee in the future in any way we can. Thank you.